morning and a warm welcome to our 2016 Employment Law Briefing. And thank you all for coming along this morning.
It's changing continually, and if you don't keep up to date with it, you can find yourself in a lot of trouble.
Despite the reduction in the number of employment tribunal claims and the consequent knock-on effect of the reduction in the number of cases being heard by the Employment Appeal Tribunal, there have been some significant cases heard over the last 12 months or so. Now, of course, as you all know, all employees by law are entitled to 4 weeks leave plus statutory bank holidays within our own laws. The Working Time Directive introduced the concept of compulsory holidays of 4 weeks. Voluntarily in the UK, we have added the 8-day statutory holiday to that minimum entitlement. And of course, the flow of cases that has arisen over the last, say, 2 or 3 years has centred around, again, what should be the rate of pay when the individual takes their holiday. And the case of Mr. Locke mentioned commission, results-based commission even must be included in the calculation for holiday pay, but importantly, only for the first 4 weeks of compulsory holiday pursuant to the Working Time Directive, not necessarily for the 8 additional bank holiday days, and certainly not for any additional contractual holiday that the employer chooses to give to the employee. The next case is Smith & Gartner UK, and this involves the provisions of Section 13 of the Equality Act. It's unlawful to treat an employee less favourably because of their age. So Mrs. Smith had quite a bit of time off sick. The odd days turned into weeks and the weeks turned into months. And when she first went off on long-term sick without a break, she was 59 years old and was able to take advantage of the company's contractual income protection policy scheme, so she continued to receive pay. Now, halfway through a long period of illness, she became 60. And upon her 60th birthday, or shortly before that, the employer wrote to her pointing out the fact that she would cease to continue to receive those benefits when she attained the age of 60. She brought a claim, went to the Employment Appeal Tribunal, and the Employment Appeal Tribunal decided it was not discriminatory because the payment ceased not as a result of the employer's desire to end the pay, but because it was a condition of the insurer's terms that they simply wouldn't pay out any more.
Employment law is a serious topic. It's ever-changing and can be very dry, but it's something that affects us all, both personally and in our businesses and organisations. It is vital that we all remain compliant.
It's a really well organised event, and it's a great opportunity to network with other HR professionals within Peterborough.
It's good to network. I think it gives you a perspective of what other companies are doing and how they react to things.
I find it very informative and very useful, yeah.